Welcome to Fairly Competing, the show providing in-depth analysis of trade secret law and the law of non-competes and other restrictive covenants. Whether you're a business owner, CEO, in-house counsel, HR executive, or other employee, or a new lawyer or advanced practitioner, join us for a discussion on the latest trends and hot topics, evolving federal and state laws, key developments, and other emerging issues in trade secrets, non-competes, and employee mobility in today's knowledge economy. And now, here are your co-hosts, John Marsh, Ben Fink, and Russell Beck.
Thank you, Erica. Here in Boston, Russell Beck.
Here in Atlanta, Ben Fink.
And here in Columbus, John Marsh.
Well, welcome, everybody. Today, we're going to be discussing a topic that I think has created quite a bit of consternation for a lot of lawyers around the country and a lot of companies around the country, and will probably continue to do so for at least the next 4 months, 5 months, 6 months, until the FTC decides that it's going to ban restrictive covenants nationally, and California won't matter anymore. So the topic today is California's two new laws that take the California ban on non-competes, expand it while purporting not to expand it, and then apply it nationally. And so the concept is that for anybody who has a non-compete agreement, a non-solicitation agreement, probably a no-recruit agreement, and an overly broad, in California's eyes, non-disclosure agreement, can, regardless of where they entered those agreements, regardless of whether they were paid for those agreements, regardless of anything about the nature of the restrictions other than they exist, can pick up and flee to California and have their agreements voided by a California court. So a CEO in Massachusetts who was paid fair and reasonable consideration for a non-compete, they live in Massachusetts, they work in Massachusetts, they get the benefit of Massachusetts laws, they get the benefit of that consideration, can pick up, go to California, and having received all those benefits, they basically extinguish the rights of the company to enforce that restrictive covenant and all of the other covenants. So that's what we're looking at. And so the question becomes, how are employers and employees going to deal with this moving forward? The complicating factor on this is that under the new law, California has made it unlawful not just to enforce a restrictive covenant that violates the law, but even to enter into one. So if a company has entered into an agreement that violates the law, the employee can sue in California and seek damages as well as punitive damages or fines and attorney's fees for having been subjected to one of these kinds of agreements. And they can turn that into a class action lawsuit. So from the employer standpoint, there's obviously a lot of concern, but we're going to look at it today from the various perspectives, the perspective of the former employer, the new employer, and the employee. And I think we can start with perhaps the employee's perspective, which is probably the easiest one. And it obviously dovetails with the new employer's perspective. But Ben, you want to walk us through your thoughts on that? And anything I missed on the statutes, if you think of it offhand now, add to it. Otherwise, we'll address as we go.
Yeah, Russell, I think the dilemma that, well, I guess you asked me specifically about the employee, and I liken it to what used to happen sometimes here in Georgia before 2011. So in 2011, the Georgia General Assembly passed a statute that made non-competes much more enforceable. Prior to that, it was all common law, and the courts were pretty hostile to them. We were not like California in the sense that, one, there was no statute outlawing non-competes, and two, a properly drafted non-compete could pass muster and could be enforced. But the reality was the vast majority of them, particularly ones drafted by lawyers outside of Georgia, even for employees in Georgia, were often not found to be unenforceable. And so what we had was companies that if they had Georgia operations and they wanted to hire someone from a competitor, they would hire that person and move them to Georgia. They would hire us to file a declaratory judgment action to ask the court to declare the non-compete unenforceable. And as part of that, we typically would not only file the DJ, but we would file and request a TRO and then a preliminary injunction to stop the former employer from filing suit in whatever state the employer was in, or where the employee had worked for them. So, let's use Massachusetts as an example. We had lots of companies that had employees here in Georgia, and they would, have a Massachusetts choice of law provision and a Massachusetts forum selection provision. But even for folks who are being moved here, they didn't live and work in Georgia. If they came here to live and work, the courts almost always, not always, it depended on your judge, but almost always would issue that injunction to stop the employer from suing the employee in whatever state they came from or whatever state the employer was based in to enforce the non-compete. The idea was that Georgia had this very strong public policy against enforcement of non-competes, and that the only way that could be protected was through an injunction prohibiting someone from filing suit in the other state. And to be clear, the Georgia courts were not enjoining other courts from doing anything. That was an argument that often got made, but it was enjoining the parties. If the Georgia court had personal jurisdiction over the former employer, then the Georgia court could enter an injunction saying you shall not file a lawsuit anywhere else. We're going to litigate the enforceability of this covenant here in Georgia. And so I think we're going to see a good bit of that. I know it already goes on in California to some extent because of the prohibition. I think the courts out there have been mixed prior to this statute on whether they would issue that injunction, but it certainly appears that that's going to be a pretty common approach, and one that will allow folks to, even if it's temporarily, move someone to California, cleanse them of their non-compete or other restrictive covenant, and then, once all that's done, decide to move them, leave them in California if that's really where they needed them, or move them to whatever part of the country they really needed them in to begin with. And so we used to joke, we had one client that did it with such frequency, they called it the witness protection program. They had all these people in Georgia who, we were trying to have their non-competes declared unenforceable. And then once they were, they can move them on to where they needed them. And so, it certainly is California trying to export its law and public policy to the rest of the country. And I don't mean to endorse that approach based on my discussion of it. We did it a lot back in the day here in Georgia, but I think today it does create all kinds of problems for employers, and something that they've got to be cognizant of as they ask people to sign agreements, or if they have people who have already signed agreements, where there's a chance that they could move to California, whether permanently or temporarily, to try to avoid the enforcement of the non-compete or other restrictive covenant against them.
So I want to make a distinction between an employee who started out in Georgia and may want to move out of Georgia versus an employee who started outside of Georgia and then was brought into Georgia. I assume you use that approach for both categories of people.
Yeah, and I will say that if it was an employee that lived and worked in Georgia, but signed an agreement again with a Massachusetts forum selection clause and choice of law clause, the courts were very, very willing to enter that injunction. I will say there was a little bit more of a mixed bag if someone had lived and worked outside of Georgia and then came here. But if they came here legitimately to work for a company in Georgia, whether the company was based here or not, the courts were willing to do it. I mean, often what we would do is make sure when the employee moved here, you've got to lease an apartment at a minimum. You got to get a Georgia driver's license. You got to register to vote. You got to do all the things that allow us to, with a straight face, represent to the judge that you are now a Georgia resident, and that your domicile, if you want to look at it that way, domicile is about intent, right? Where do you intend to live? There was nothing that said you had to intend to live in Georgia indefinitely, but for the time being, is your intent to live in Georgia. And if the more of those things you could show to a judge, that this is not just some ruse, this is not just, something where we're trying to pull one over, but genuinely the person has moved here, even if the ultimate intent was that it would be temporary. The judges were pretty accepting of the idea that they should prohibit the employer from seeking an injunction in the other state or filing suit because that person, as a Georgia resident, was entitled to the protections of the Georgia law and public policy, which at the time was, hostile to non-competes.
So one thing I think from the description that you've provided, and that would also apply in California, is it can't be a sham move, right? It can't just be somebody, somebody has no real intention of being there for any period whatsoever, right? And to your domicile point, it has to be the plan to be somewhere indefinitely. So there will be some fighting around whether the move is a sham or not. That at least was true for Georgia. It will be interesting to see whether that is true in California as well, right? So if somebody's trying to enforce an agreement in Massachusetts, using that as the example, and the employee flees to California and then tries to file a declaratory judgment action seeking an injunction to prohibit the former employer from pursuing any claim outside of California, presumably the Massachusetts court is going to be very interested to determine whether the move to California was a sham, to the extent that the Massachusetts court is willing to consider the argument at all. But I'm not sure whether the California court will be so interested in knowing whether it's a sham or not. The statute doesn't even talk about how long you have to be there or anything like that. It is simply that people in California can't be bound by non-competes or these other restrictive covenants. So,
yeah. Now, one interesting sort of side issue that came out of all of those cases, the Georgia state courts, here we have state and superior courts. The superior court has equity jurisdiction. So that's the trial level state court you would go to if you're seeking an injunction. The superior courts would often issue that injunction, and it was nationwide or worldwide, basically telling the company, look, I have jurisdiction over you, and you were ordered not to file suit somewhere else to try to enforce this. And the Georgia Supreme Court ultimately upheld that injunction, and that injunction could have nationwide effect. Interestingly, there were some federal judges that would issue that injunction with nationwide or worldwide effect. And then there were others that would limit it to the state of Georgia, saying to the employer, you can't sue to enforce this covenant in Georgia, but I'm not going to say what can happen anywhere else. And there were, in one of the cases where the judge had issued a nationwide injunction, the 11th Circuit reversed and said it was error for that injunction to apply anywhere outside of the state of Georgia. Now, I never agreed with that decision, because if you think about it the other way around, if the employer is going, let's say a Georgia company is going in to enforce a non-compete or any other restrictive covenant against an employee, and the court issues an order saying thou shalt not, compete, or thou shalt not solicit customers, those injunctions are never limited to the state in which the injunction is issued, right? So the idea that the courts were limited, the federal courts were limited to the borders of Georgia when it came to issuing those injunctions was an interesting sort of development. And I'll be curious to see if someone tries to make that same argument out in California and ultimately the Ninth Circuit. Like, look, your courts here can enjoin people from doing things in California, but they can't. A federal court in California can't enjoin someone in Massachusetts from filing suit in Massachusetts. Now, again, I don't necessarily agree with that decision, but that was the law in the 11th Circuit, and it still is technically.
I guess one of the takeaways from that is if you're on the employer side, you will make that argument. But the problem is, even if you were to succeed on that argument in California, the employee still has the ability to bring a claim for damages. Right. So even if they are enjoined, the statute is really nuts. And that, I think, is probably the biggest concern about the statute, is that even if you pursue them outside of California, they still can bring a separate action in California for damages and fines and attorney's fees and make that a class action. And I think that's where we're going to see the biggest hammer for companies to rethink what they're doing for their agreements.
I have a question for you, Ben. In terms of, there's obviously a practicality threshold for what we're talking about, because this isn't just simply a rather modest investment of time and resources. We're talking about probably an individual that's got to be significantly important to move them out to the state, there has to be a presence in California that justifies some legitimate business interest, if you will, or at least connection. And it's more than just somebody staying at a residence inn for a month or so. I mean, we're talking about all these indicia that you really need to have to show that there is at least some intention of residency. And again, I recognize that the California statute doesn't speak to some of these issues, but I'm interested, as somebody that hasn't had to be involved in these races to the courthouse with the frequency that you and Russell have, economically, what are the types of positions that generally trigger an employee and a new employer's willingness to make this commitment at the end of the day? Are they only C-suite individuals? Would it be a particular technology or business opportunity that is so valuable? I don't know. I'm intrigued by those questions that sort of present themselves at a practical level to a new employer and a new employee.
Yeah, I mean, the example I was giving about the client that called it the witness protection program,
right?
They were in the construction industry, and I won't use the exact trade, but let's say it was a framing subcontractor, a national large framing subcontractor. I mean, they were doing it with salespeople. They would bring them here, and these are people making, $100,000, $150,000, $200,000 a year, not necessarily C-suite people. Now, in today's world, in today's economy, I think that's less likely maybe, but I think you're right. It's going to be more the C-level folks that a company's going to be willing to make that investment. But, the reality is it's not a huge investment, right? You get a corporate apartment for, a couple $1,000s a month. You have somebody go get a California driver's license, register to vote, and you can walk in with a straight face and say to a judge, look, this person is a California resident. So I don't know that there's really that much expense involved. You got to find the person who's willing to move there maybe, for some amount of time, several months or more as litigation plays out.
Well, actually, that raises another question, which is the timing. So in the past, putting aside your Georgia experience and putting aside the California issue, which has always been out there, to your point from before, most often companies are sending a cease and desist letter. So now there's time for the employee and their new employer to react and come up with their strategy. In that window of time, the employee now could move out to California. Obviously it'd be something that was planned. They move out to California, they get their apartment, they get their driver's license, they do all the other things that show that they are intending to re-domicile there. But what is the employee who doesn't receive a cease and desist letter supposed to do? So the former employer gets notice on a Friday. The employee moves out Friday night to California. The employer says, I'm going to go into court on Monday morning. And they do, right? They file on Monday morning. The employee doesn't have any time to really establish themselves as an employee out in California. So how is it that they're supposed to show the indicia of change of domicile? What have you guys done in the past?
Yeah, I mean, it was never that quick. Not that I can recall. Usually the person had left the former employer and then, they sort of came here under the radar and got themselves established. And then, the cease and desist letter would arrive and we'd go running into court, or sometimes we'd go in before. Now, the risk of going in before any kind of cease and desist letter is in most states, and I assume the same is true in California, to be able to state a claim for a declaratory judgment is there has to be some indication from the other side they're intending to try to enforce the covenant. So, I did go into court a few times without that, and it was a little harder. The former employer could come in and say, oh, judge, we weren't intending to enforce the non-compete. We'll take a wait and see on the customer non-solicit, but there's nothing to see here. There's no controversy. There's no case or controversy. And, I probably was more successful on that on the defense side by going in and just saying, judge, look, no one's threatened to enforce anything. So you can't rule on anything. Now, I don't know if there's something in the California statute that would give the court the ability to rule on it, even if the former employer has made no effort to threaten enforcement.
That's a great question, right? It's the standing question. Sorry, ripeness question.
Ripeness. Yeah, that's exactly what I was going to say. And just to chime in reality, if somebody resigns, provides whatever story about what they intend to do, in my experience, most employers don't react until they either learn the identity of the new employer, and it depends on where they stand on the spectrum in terms of risk, or alternatively, there's evidence that somebody's officially misbehaving, whether forensics have been done, whether customers are calling, other employees are reporting being solicitation. That's sort of the trigger we all respond to, and that affects the timing of your non-compete and whether you're even going to bother sending a cease and desist letter, right?
Agreed.
Yeah.
And so so I'm just looking at the language of the statute that says an employer shall not enter into a contract with an employee or prospective employee that includes a provision that is void under this chapter.
So I guess what I'm saying, Russell, is the scenario that we were talking about, maybe the new employee and the new employer aren't really at risk until somebody knows that they're violating the agreement or they're taking actions inconsistent with the agreement. And presumably they're doing the same calculus we're talking about right now, which is this person's sufficiently valuable that we're willing to move them out to California temporarily, invest time in hiring a law firm, filing a DEC action. And it would seem to me that it provides a significant strategic advantage to the new employer and the employee, because they can, I don't want to use the word orchestrate, that's pejorative, but they certainly can plan.
Hey, Russell, I want to understand or get your thoughts on the damage claim. So when you say there's this risk.
Wait. Can I pause you on that? Because I just want to address the rightness point. Because because you raised the question, maybe California says something different. And I don't know what California law is more generally, but I can tell you that this statute raises concerns. So reading the language of the statute, an employer that enters into a contract that is void under this chapter, and I'm going to ignore the or attempts to enforce language, commits a civil violation. So it is the mere entering into a void contract, which means that, read on in the statute, an employee, former employee, or prospective employee may bring a private action to enforce this chapter for injunctive relief or the recovery of actual damages, or both. In addition, there are some other remedies. That seems to suggest that you don't need to wait for the employer to threaten the suit. So the ripeness issue that we were just discussing, while probably true in every state in the union, doesn't apply in California. That's my take.
I think you're right.
We could just file a DEC action challenging it out of the gates.
Yeah.
And so I do think
that's what I would expect.
And I do think that's different from what we had here, because again, ours was just all common law. So you may be right.
Yeah. And what's crazy about it is that the contract is void regardless of where it was entered into, like once the employee is in California. So it's I mean, this has to be unconstitutional, putting anything else aside. But go ahead. Now I had interrupted you in your question about damages.
Yeah, so you mentioned that the real concern or the threat to all the companies that are outside of California is the idea that one person or some group of people can move to California, can file this action, and can file for damages and attorney's fees, and that there's a threat of a class action. And I'm trying to understand how that could work. So can someone file in California and seek class certification as to every employee of the company everywhere in the country? That just seems to me to be a little far-fetched, right?
I agree with you.
Okay.
Except we're in California. So let me tell you what the statute says. A violation of this section constitutes, and so the section is, the company will not use these agreements, right? That the company can't enter into these agreements. So just for everybody's so that everybody has the sections we're talking about California Business and Professions Code sections 16600, 16600.1, 16600.5, and then it goes on beyond that. But those are right now the key sections that we're talking about. 16600.1 C says that a violation of this section constitutes an unfair competition within the meaning of Chapter 5, commencing with Section 17200. That is I think it's their unfair business practice or unfair labor practice statute. And that's where you get the fines. I think it's $5,000 per violation. So the damages, now to actually answer the question, the damages for an individual, and we'll talk about class, but the damages for an individual are, number one, $5,000. Number two, any job that they have been theoretically restricted from taking may provide a claim for damages, the increased wages that they would have received had they gone somewhere else. All they need to do is bring in someone, one of the academics who's done research on the area that says wages have been depressed by noncompetes, and say, my wages were depressed by noncompetes, and here's my expert to testify to that. And they've done all these studies on this. That'll all be challenged, obviously, but that's your $5,000 plus your actual damages, plus your injunction, plus your attorney's fees. Now expand that out and say, well, they have the same contract with X number of other people in the company, and they've used them, starting back at least as of January 1, 2022, because that's the date that this statute kind of looks back to for when somebody needs to get notice of it. So let me back up on that. The statute requires that by Valentine's Day, when you send your flowers to your employees and former employees, you also send them a notice saying that any non-compete that you have is invalid. And again, non-compete is non-compete, non-solicit, no recruit, and overly broad non-disclosure agreement. So you have to send that by February 14 in 2024. The failure to do that, for any particular employee, is a violation of the statute, and again brings us back to all the claims that the employee can raise. At a minimum, anybody who is in California would be similarly situated, such that they could be part of a class. But rest assured, you are going to see people claiming that this invalidates these contracts around the country. And so, I am just one of many people who would like to come to California and be free of their agreements, but we feel that we can't. And now we're bound to either have a lawsuit if we move to California because we've got these agreements. And so I'm standing up for every other employee of the company who would otherwise move to California. Now, should that be a class action for, the non-California people? No. Will it be a class action? We're in California, no holds barred. So anyway, so that's where I think there's a risk. And then it's the attorney's fees, right? So this is a setup for claim after claim after claim. And what you will also find is that there are going to be a lot of employees who are employed by non-California companies, but they happen to already reside in California. And for those employees, now you've got a statute that says it's not just unlawful to enforce the agreement or that the agreement is void, but that it's unlawful to enter into the agreement in the first place. And that the language of the statute is that this section shall be read broadly in accordance with Edwards versus Arthur Anderson to void all these contracts, whatever. This subdivision does not constitute a change in, but is declaratory of existing law. So what that's setting companies up for is for the class action lawsuit for employees in California to say, well, look, even prior to this, it was illegal in California to enter into a non-compete agreement that violates the statute. And so I want my damages for that, and everybody else is going to get their damages for that. That's going to be part of the argument. And there are responses, different sections, different subsections of the statute, and what they're reading is in 16600. It's not in 16600.1c, which is not the same subsection. So you're going to have all that kind of wrangling about this. But until this all shakes out, there's a lot of potential exposure, I think, for companies. Were you going to say something, Ben? Or
yeah, well, I was going to ask, whether you've formulated a, sort of plan for clients that either have employees in California or don't. But, what are you thinking in terms of what companies should do? I mean, I certainly wasn't planning to have every client just get rid of all their non-competes for all their employees around the country. because of this risk. I mean, I understand it's a risk, but I'm curious if you have a different take.
No, I totally agree with you. I totally agree. You can't get rid of your agreements for people who are outside of California. I think a reasonable reading of this, and one that at some point some judge will say is the right read, is that regardless of what happens when the employee moves to California, anybody who enters into an agreement with a non-California based company is free to enter into a non-compete as long as it complies, with their other state laws that may be applicable. But that California doesn't have the ability to say, you in Massachusetts, you in Georgia, you in Ohio, you can't enter into a contract with your Massachusetts, your Georgia, or your Ohio company, right? Your Ohio company and Ohio employee, they're free to negotiate whatever they want to negotiate. And I do think that that is the right read, irrespective of whether somebody then moves to California. So it's only at the point where somebody moves to California that I really think that you'll have the problem, in fairness, notwithstanding some of the, potential arguments out there. So what am I telling clients and anybody who will listen is that you need to be aware of this. If you have people in California, whether you are a California employer or not, you need to be making sure that your agreements with those people comply with California law. I don't think you're going to get around that. For people who are outside of California, you can have whatever agreements comply with the applicable laws, but then you need to figure out what your plan is going to be for somebody who moves to California. And that may vary based on different state laws and different procedural laws in different states. And for that, there's a split in the circuits, the federal circuits, about whether they will apply, let's take California's law that requires venue and choice of law in California for any dispute for anybody who's in California. And you contrast that with an agreement that says, even though you're in California, you're going to litigate your agreement in Florida, where the company is headquartered. So what will a court do in terms of enforcing the choice of forum? Let's start with. There's a split in that, a split in the circuits on that. And some courts say, no, we're going to apply, you are in a court in Florida. We are not going to say that California's forum selection law governs. You've agreed to the jurisdiction of Florida. We're going to have it in Florida. But there is a case out of federal court in Virginia in which the court said that the Massachusetts statute, which says that any non-compete dispute needs to be resolved in Massachusetts for a Massachusetts resident, does not apply in federal court. That's a procedural issue. And the federal courts have their own procedural rules, and therefore the case is properly venued here in Virginia, where I think the company was headquartered, and also where the employee had agreed to have it litigated. So I think we're going to see that issue come up, but that doesn't stop the employee still from bringing the separate lawsuit in California for damages, which is a separate issue under the statute.
Yeah, so that's the question I've got, right, is what are we going to do? And I had this situation last year where we had a client, they had a very senior executive move to California and take a position with a competitor, and we sued here. And even before this law, we were concerned about him going into court in California to try to get an injunction or to, sue. He never did. I was kind of surprised by that. But, so once this law takes effect, are we going to sue a person who we know has moved to California in Massachusetts or in Ohio or in Georgia to enforce a non-compete that has a Georgia, Massachusetts, or Ohio forum selection clause and choice of law clause? And I guess if we are, it's certainly got to be with the understanding the client knows that they can and probably will get sued in California for damages, right?
Totally agree. So I think there are two things that I would be thinking about. And actually, I realized that I did not give you the other half of that equation. The other half of that equation is there are some courts that say, no, I'm going to enforce the California or the Massachusetts choice of forum provision. You need to go to that state. So depending upon where your client is located, they may have a different perspective on whether to use a forum selection clause for somebody who may find themselves in California. But going back then to your current question, I think the advice that we need to give clients is that they need to consider what's going to happen when an employee moves to California. If the employee moves to California, are they going to take the position that at that point, any restrictive covenants are gone? And I would write that in the contract if that's the expectation. Or are they going to say, no, we are going to try to enforce this outside of California? And I think to your point, Ben, the client has to make that choice, and they need to understand the risk associated with that choice. But I think that's a real valid question. And I think that the exportation by California of its policies strikes me as completely unenforceable, ultimately, probably unconstitutional. And at some point, it's going to need to be adjudicated. If it's adjudicated in California, I mean, it's not going to be adjudicated in the state court. It'll be adjudicated in the federal court. And the federal judges there, I think, are generally pretty reasonable. Hopefully they see this as a constitutional issue and say, California legislature and governor, you've overstepped, but perhaps not. Perhaps the Ninth Circuit won't, but rest assured the Supreme Court will. So
yeah, well, that
good luck
could
getting
raise
there. Good luck getting there.
Could raise some really interesting full faith and credit issues. So let's play it all the way out, right? You sue in Massachusetts, you get a permanent injunction against an employee who has moved to California enforcing the non-compete. In the meantime, the employee sues for damages in California and gets a money judgment against the employer. Does California have to give full faith and credit to the final judgment that's been entered in Massachusetts enforcing the non-compete? And then does Massachusetts have to give full faith and credit to the money judgment that the employee got in California? I'd love to have that case. It'll be a lot of fun.
That is a great, you and me both. I would love to do that. It's going to be, all of this is going to be interesting. And we're going to have to see how it plays out. I mean, I think the other things that companies should be thinking about is, number one, the notion that an ounce of prevention is worth a pound of cure, I think is all the more important now. Companies really need to be taking steps to step up their trade secret protection programs and to figure out how they're going to protect their customer relationships. So they really need to be doing the things that they can do absent an agreement to protect their information and their relationships. That's number one. Number two is they can be thinking about and should be thinking about how else they can insulate themselves from California's law. So what agreements can they use that might actually pass muster under California law? Certainly narrow non-disclosure agreements are going to work. I don't think that that's enough. I think they're going to need more than that. So what else can they do? I'm a big fan of the springing non-compete concept, or as John calls it, the timeout non-compete. For those who aren't familiar, that is an agreement essentially that says you don't have a non-compete, but if you violate your other restrictive covenants, then the court shall impose, or you're going to ask the court, you can agree that the court will impose a non-compete as a remedy. That's the concept of it. And I think that's, there's a question about whether that would constitute a non-compete under California law. And so if it does, you're right back where you started. But I think there's a pretty good argument that it doesn't constitute a non-compete. It's just a remedy that we're talking about, letting the court impose that. So those are the kinds of things I think companies need to be thinking about. What else can they do? Maybe ERISA top hat plans where they include non-competes as part of those. Agreements like that get the benefit of ERISA law. And so state law is preempted. So it should be the case that the non-compete can be enforceable under that. Whether a court in California would grant an injunction is a whole separate question. But at least there's an argument that the employee can be required, that the employee can at least enter into that agreement, and there should be some benefit to the employer. Other types of agreements are, I suppose, like forfeiture agreements, right? If you leave, you're allowed to leave, you go wherever you want, but you forfeit some right that you may have otherwise had. Companies may choose to enforce that when an employee leaves and goes to a competitor, but not enforce it if they leave and don't go to a competitor. I suppose, if that happens, California courts are probably going to say, well, it's a de facto non-compete now. You're using your forfeiture agreement as a non-compete. So for every idea there is a counter idea. And I think that this is going to take a little while to figure out. For those who haven't heard it, we had a 2-hour roundtable discussion about this. We'll include the link in the notes, but the end result of 45 or so lawyers, like the three of us who do this work around the country, came up with a big shoulder shrug. Yeah, we don't know what we're going to do. This is going to take a while to figure out. And there's a lot of disagreement among people who are knowledgeable in the area. And there's a lot of confusion among people who are knowledgeable in the area. So it'll take some time to sort all this stuff out. But I do think that companies need to be thinking creatively and think about what they really need. And in the meantime, making sure that they're taking whatever steps they can to insulate themselves from the risk posed by an employee who might go to a competitor.
Interesting times, huh?
Certainly true. Anything else we should cover on this topic?
I can't think of anything. I think you laid it up pretty well. And I would echo what you say, Russell, in terms of greater primacy to trade secret protection and focusing on the non-disclosure agreements. It's just good practice, not only because of the events in California, but based on what the FTC has to say about overly broad non-competes or de facto non-competes as they've characterized overly broad NDAs. So I think you're spot on in advising people that they ought to be revisiting those and looking at how they can make them more narrow.
Yeah. I mean, the steps like data loss prevention software are, I think, critical at this point. And really making sure that companies have a handle on what information they have, how it's currently being protected, and what they need to do, if anything, to beef up those protections and make sure that the information is secure. The same thing for customer relationships. A lot of companies have one point of contact between the company and very significant customers. That's not a great idea. I get that that's the most efficient, but on the other hand, if you've got only one point of contact with a number of your key customers and that point of contact leaves and non-solicitation agreements are no longer valid, you are putting your customer relationships and all the business associated with those at risk. The phrase that I had heard years ago from a lawyer who was general counsel at a client was single threading the relationship. You really don't want to single thread a customer relationship. So companies need to be thinking about those kinds of things as well. Is there a way to protect the relationships, to secure them so that if an employee leaves, the company's relationships are protected? Now, the problem, of course, winds up becoming, well, what happens when multiple employees leave at the same time? Then you may have a breach of the fiduciary duties that the employees owe, and there may be claims based on that as well. So outside the scope of a restrictive covenant. Anything else on this topic?
No,
I think that covers
we've
it.
spent a lot of time on it, more time than I thought we would.
Yeah. Well, I think there's a lot of, at this point, shoulder shrugging, and we're going to have to wait and see what winds up happening. It's everybody's best guess right now. And I think some good brainstorming, continued brainstorming, as well as thoughts from in-house counsel and from business people about what is it that they really need to do and what is it that they can do to protect the relationships and information. Well, we'll wait and see what happens. And hopefully somebody will challenge the law very quickly and we'll be surprised and some judge will overturn it and say it's unconstitutional and even before you go up on appeal. We shall see.
That concludes today's show. You can visit the official podcast website at fairlycompeting.com. And please note that this show is provided for informational purposes only. None of your hosts is providing legal advice, and your use of this podcast does not create an attorney-client relationship in any respect. Thank you all for joining us.